Good morning, good morning, good morning, good morning, everybody, and a very warm welcome to you to this third edition of the Family Law Roundup. And this time around, we are looking at the recent cases that came to my attention in February, even if some of them were not handed down in February. I've got 20 very, very interesting judgments for us to look at as we work through the last calendar month of developments in family law. It's absolutely lovely to have all of you in with us this morning, and I really look forward to chatting with you. So, without further ado, let's get started. Today, we have a couple of Rule 43s, we've got a couple of divorces, we've got some procedural issues, some international travel with children, and some customary law. The overwhelming majority of cases we will be looking at today come from the Johannesburg High Court. Close second is the Pretoria High Court, then a couple from the Western Cape, one from Limpopo, and then one from the two, in fact, from the Free State. I look forward to going through the list with all of you folks, and I hope that you enjoy the roundup, and I hope that you enjoy the summaries as I present them to you, as much as I enjoyed preparing them. So this morning we are very, very pleased and very proud to announce that our thinklegal.co.za website is finally up and running. You are welcome to go visit thinklegal.co.za. You can register for events, you can join our WhatsApp groups, purchase resources, and view past webinars. So in terms of the WhatsApp groups, for those of you who are not yet on the Family Law WhatsApp group, please pop through to thinklegal.co.za. You will see a nice big button right at the top where you can join our WhatsApp communities. Then further from that, I would like to tell you what Think Legal is all about. For those of you who are new to the Think Legal community and who are joining us for a webinar for the first time and hopefully not the last time. So, Think Legal. We believe in legal knowledge open to everyone. It's an initiative by Vermeulen Attorneys which aims to promote the open sharing of sound legal knowledge and has been doing so for almost 4 years. While we acknowledge that the delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is and should be a public resource meant to be freely available to everyone. Adhering to our dedication to facilitate open dialogue and share legal knowledge among professionals, we organize a variety of activities, including the management of WhatsApp groups, webinars, and social events. This event today, as I'm sure you all know, is absolutely free. We are planning on keeping all of these events absolutely free, save for the optional course pack, which I will tell you about shortly. Before we get into that, Think Legal is supported by Vermeulen Attorneys and Lawbox practice management software for lawyers by lawyers. Try Lawbox free for 14 days. www.lawbox.co.za. No credit card, IDs, or other compromising information required. I just finished last night presenting our newest course that we've prepared called Divorce 101. Thank you so much to everyone who attended this course with me. It was really fantastic working we had a room of about 55 people on most evenings, and it was very, very interactive. It was an absolute joy to present it. And we are going to keep it going back to one of our old and one of our first deep dive courses. We are doing the Children's Act deep dive, newly revamped and reaccredited through the South African Association of Mediators for 5 CPD points. We are running it on the 23rd and the 24th of April as an evening course to ensure that you don't have to take time off work to attend. Attendance is 750 Rand for attendees, candidate attorneys. Bless you, you can all get 500 Rand to attend to help you in your own professional development. Use the promo code TL Early Bird for 20% off until 20 March 2024. To register, all you have to do, go to thinklegal.co.za as you see on the screen. Click register now under the deep dive icon. Right, we are almost through with our admin, and then we will get started with our 20 cases that we are going to run through today. Folks, as I mentioned to you earlier, the attendance of this webinar or watching it on demand is absolutely free of charge, whether you are watching on StreamYard, YouTube, or LinkedIn. You are more than welcome, and we expect nothing from you save that we want you to have a good time. Apart from that, you are more than welcome, if you feel so inclined, to purchase our course material. It is 250 Rand, which gets you the case law bundle, which we will be talking through today, paginated. It is 300 odd pages of case law. It gets you our slides, which we will be running through, and it will get you my summaries, which I did, which is an 18-page summary, which looks like you see on the screen as a free taster to fast track you into understanding these cases. As I mentioned, this is completely optional. We do not expect you to do so. We won't bar you from future webinars if you don't do so, but I do believe it is a good resource to have in your practice, just to fast track you into what has been happening throughout the courts in South Africa. Throughout the webinar, I'm also going to be referring to the page numbers of these resources for those who would like to follow along. Very importantly, as you would have seen on our advertisements for this course, we have accredited the course with the South African Association of Mediators and the Social Justice Association of Mediators, with the other accreditations with the other two NABFAM bodies still in process. As soon as we hear back, then we will add those CPD certificates as well. If you attend today, please make sure you attend via StreamYard so we can make sure that you are here. If you want a CPD certificate, please go to the store, purchase the course material for use in your practice, and then select whether you want a SAM or a SJAM CPD certificate. Once again, to access the store, you can simply go to thinklegal.co.za and click on Think Legal Shop, and you'll be able to find all of our summaries there. So without further ado, folks, friends, esteemed colleagues, let's get into the February Family Law Roundup. We have some very exciting judgments to go through, very interesting judgments, and I would love to hear from you in the comments or in the chat on StreamYard what your thoughts are regarding the judgments. Please make it as interactive for me as possible, because then I can try to make it as interesting for you as possible. So, starting off with Rule 43, we are working first through a Western Cape High Court matter, CA versus HA, 5578 of 2022, and that judgment landed on the 30th of January 2024. Those who are following along in the case law bundle, the judgment is at page 1. Those who are on page 13, my apologies. On the summary page, you can find this at page 7. So you'll see on the screen, I give you the basic case name and a notable quote. I'm going to go through a little bit more details from our case law summary in order for you to understand the the case a little bit better. Now, please understand, folks, this is 288 to be exact pages of case law. I'm trying to condense it for you into no more than an hour and a half, and preferably an hour and a little bit session. I know we are all very busy. That being said, it is impossible for me to fly through these judgments and to give you a full rundown of exactly what happened in each case and all the nuance. Some nuance is going to be lost, but hopefully this will be a good way for you to fast track yourself into reading the case and to understanding the case and knowing where to go and look for certain things. So CA versus HA, Western Cape High Court, Cape Town. Judgment was penned by Inziweni J on 6 February 2024. And this matter deals with Rule 43 interim maintenance and spousal maintenance. So this was a marriage of long duration. The parties were married on 1 July 95, marriage out of community of property with the accrual system, and divorce proceedings were instituted as far back as 17 May of 2022. The applicant approached the Rule 43 court for a Rule 43 order where they wanted several orders in terms of maintenance for themselves. What this judgment deals with is disclosure in Rule 43 matters, and the principle that Rule 43s require full, honest, frank, clear disclosure of financial affairs, the principle of clean hands. And essentially what happened in this matter is the application was struck from the roll due to applicant's failure to fully and honestly disclose all the material facts regarding her financial situation. Each party was ordered to pay its own costs, so the applicant was not mulcted with costs. However, it is very, very interesting to see the stance that is being taken by the Western Cape High Court regarding disclosure and non-disclosure, shall we say disclosure or lack thereof, in Rule 43 matters, particularly in light of the judgment by Kluter J in October last year regarding Rule 30 and prolixity in affidavits, etc. I know many of our friends and colleagues in the Cape are lobbying very, very hard for the introduction of financial disclosure affidavits and financial disclosure forms as we have them up in Gauteng at the moment, which I think will certainly be of much assistance to judges and to litigants in Rule 43 matters. So we are all holding thumbs that you will get your FDFs soon, Cape Town colleagues. A very interesting quote from the judgment on paragraph 18. As mentioned earlier, the principle of disclosure is of utmost importance in any Rule 43 applications. Likewise, in a Rule 43 application, it is expected of an applicant to demonstrate a measure of candor and diligence in disclosure of his or her personal circumstances. An applicant cannot simply elect to place before a court only those facts which are going to be favorable to his or her case and withhold those that are detrimental to the case. To that end, it is expected of an applicant to disclose full facts in the founding affidavit, which might have an influence on the court's decision. It takes us all the way back to the principles of Dupria versus Dupria. You have to approach the court uberime fidei, tell the court what is going on, and if you do not do so, you run the risk of not getting relief in terms of Rule 43. So a very, very interesting matter, CA versus HA, all the way from the Western Cape, Rule 43 interim maintenance, and a matter removed or struck at least from the roll due to non-disclosure by the applicant. Very interesting that the matter was not dismissed. One would then surmise that the applicant would have an opportunity to do a Rule 43(5) affidavit to place all financial information before court, but obviously they cannot simply do that just as of right. So very, very interesting Rule 43 judgment in a line of very interesting Rule 43 judgments from the Western Cape High Court in respect of Rule 43. So next up, we have the matter of TE versus VE. I am so sorry to my friends who have purchased the course pack. I'm going to make you page a little bit. You can find it in the bundle on page 226 and in the summary on page 10. The reason for that is I prepared the bundle chronologically as the judgments came in, and later on I reordered everything into various categories just to make the presentation run a bit smoother. So TE versus VE 2024 ZAGP JHC 91. The judgment landed right in the beginning of February, 2 February 2024, and the judge von Ludwig AJ. Very interesting judgment, a very nice Rule 43 judgment to read, in that it is crisp, it is clear, and it goes through the necessary information quite quickly and concisely. What is an issue in this matter? It was a Rule 43 interim care and maintenance. There was a request for a contribution to cost, and then also by consent bonding therapy was ordered in respect of the minor children, obviously within the capabilities of the Rule 43 court to do in terms of the definition of care. So what happened? The applicant approached the Rule 43 in respect of interim care and maintenance, and also sought a contribution to costs. Early on in the judgment, the court commends the parties for agreeing on an assessment process, which is something that we're seeing quite a lot in Rule 43s these days, given that they happen quite early in the proceedings, and that it is almost invariably necessary for some sort of assessment process if parental responsibilities and rights are in issue in the divorce. The key word in this judgment is balance. The court sought to balance the interim maintenance to maintain the children and the parties' lifestyle without burdening the husband in this case, who was the sole income earner. And the court, I think, in this case had a very invidious position. And the judge says in the beginning, that you have to really strike a balance between what is reasonable, what do you need to live, and how much money is there in the pot. The reality is, obviously, as all of us know, that in the context of divorce, especially if there is one breadwinner who now needs to support two properties or two households, it does become a bit of a financial tightrope that needs to be navigated. Then what happened here and what was considered? Obviously, the court restated the purpose of Rule 43. The court looked at the importance of accurate financial disclosure and the court's challenges in adjudicating financial aspects in divorce proceedings. Obviously, in this case, fortunately, being in Gauteng, in Johannesburg, the court would have been privy to the financial disclosure forms of the parties. And then from paragraphs 5 to 11, there is an interesting discussion on the court's role in creating this balancing act. So there was a Rule 43 order granted in terms of some of the aspects. For example, the assessment mechanisms. A lot of this was done by consent with a little bit of intervention by the court just to change wording here and there, which is evident from the judgment. And then the judge made a order in terms of Rule 43, in terms of interim maintenance, and for a contribution to cost, which the court kind of said, well, neither party is going to really be happy with this. I've put the one quote up on the slides for you, but I will share both of them with you. The one is paragraph 5. The court is then tasked to determine what is best for the children and how whatever money is determined to be available or at worst accessible for interim purposes can be apportioned in a way that ensures all role players are able to live and continue through the litigation, or hopefully towards a resolution, in the best possible way for their particular set of circumstances. Very interesting that the court makes it quite clear that this is not an ideal set of circumstances. You have to do what you can with what you've got. Then further on, paragraph 11 reads as follows: as such, the court has arrived at the figures which are ordered below, far from what the respondent sought, but almost double what the applicant offered. This is a result which will leave both parties unhappy. But respondent and the children must eat, get about, have toiletries and other usuals, and the home must run. Applicant has been able to access interim funds from somewhere and must continue to do so in the short term. It is up to the parties to ensure that the litigation proceeds expeditiously so that this is not longer than it needs to be. And whilst parties should stay out of court if at all possible, there is always a remedy if the circumstances of either should change materially. And that obviously referring to Rule 43.6 mechanism based on a change in circumstances. Very interesting judgment. The exact order, I'm quickly going to pull it up on my side. If I can just get Adobe to cooperate with me, I will share with you exactly what the order was. It was quite a substantial contribution to costs. I think it was 100,000 Rand or something to that effect. Let me quickly get my bundle open, and of course Adobe is not working with me. Let's scroll down at the speed of white lightning, and then hopefully I can share with you. So obviously there was the order with regards to primary residence and contact. Then there was the order with regards to bonding therapy. So order 1, full PRR. There was an assessment. Then there was orders regarding the parties making themselves available, who pays for it, what will happen pending this, and then essentially the Rule 43 financial order was to the tune of a few thousand rands in terms of contributions, and then contribution to legal costs of grossly underestimated 452,000 Rand payable by installments to the respondent's legal team. Now, very, very interesting judgment evidencing the balancing act that has to be struck by judges in Rule 43 matters, and the question, obviously, how one can make the judges' lives a bit easier. I think, obviously, the financial disclosure affidavit goes a long way towards doing so, in that it is standardized, it is under oath, and it is fairly concise. Right, next up, folks, we have the judgment of RA versus HA. This is another judgment coming all the way from Johannesburg, penned by Melindy J. on 12 February 2024. For those of you who are following along in our summaries and in the bundle, you can find it in the bundle on page 206. On your summaries, you can find the summary on page 15. So, what happened in RA versus HA? Rule 43 happened. Well, obviously, but what happened in the Rule 43? The applicant sought maintenance for themselves and for the two children, as well as a contribution to costs. The applicant highlighted their dependency on the respondent for financial support, and this is another balancing act matter where Melindy J takes very similarly an approach to von Ludwig AJ in penning the judgment, in terms of pointing out that there is this invidious position that the court is in terms of a balancing act. So, judgment deals with the purpose of Rule 43, and that the proceedings are to ensure that a financially weaker spouse and children maintain a reasonable lifestyle pending divorce. Now, obviously, reasonable is a subjective term, and that is on a case-to-case basis that you can find from approximately paragraph 20 of the judgment. It talks about both parties' obligations to the financial upkeep. And then it talks at paragraph 23 about the court's discretion to moderate and to adjust claims to align with the parties' financial capabilities and ensure fairness. What had happened here, that there was an order granted in respect of interim maintenance and a contribution to costs. And let me find the portion in the judgment, then I'll tell you exactly what was ordered in this matter. The contribution to costs, well, there was quite a lot of 3,000 Rand per month to the minor child, plus direct payments to the service provider, cell phone, school, fuel, school fees, half of extra lessons, books and stationery, tertiary education. Then towards a major dependent child, 2,000 per month, 1,500 towards fuel, plus direct. Then in respect of the applicant, cell phone subscription, motor vehicle installment, and insurance, and then a license renewal, and medical aid, and then a cost contribution of 40,000 Rand to the applicant's legal costs. And this was obviously per Malindi J. Two very interesting quotes from this judgment, which I would like to share with you. One is on the screen, as you can see right now. The other I will read out to you, which is included in the summaries, which you can obviously access through our online store. At paragraph 22, the court says a balance has to be struck, therefore, between the respondent's needs and his obligations to the applicant and their children. A balance has to be struck, therefore, between the respondent's needs and his obligations to the applicant and their children. Excuse me, that's what happens when you try to squeeze in way too many webinars into a week. Right, then the second very interesting quote is from paragraph 20 of the judgment, which is on your screen, and it's a little bit longer, but essentially says the authorities are clear that Rule 43 proceedings are an interim measure until the divorce proceedings and the proprietary aspects governed by the marital regime have been resolved. The interim relief is designed to provide the applicant or partner with a reasonable lifestyle pending the finalization of the divorce. Purpose is to ensure that partner who was being maintained by the other or who was contributing less than the other in maintenance of the home continues to live a reasonable lifestyle until divorce proceedings are concluded, where the full proprietary rights of the parties will be resolved. Rule 43 is not intended to resolve these issues on an interim basis. Secondly, the purpose of the rule is to ensure that the less financially able of the parties is not prejudiced by lack of representation or inadequate representation in the divorce, in the main action, or in the Rule 43. That was our third Rule 43 judgment, and that was RA versus HA, and that was penned by Malindi J in the Johannesburg High Court on 12 February 2024. Moving swiftly along, folks, I have one judgment for you regarding pension funds. I've put it under the heading of pension funds, but it does deal with some procedural issues as well. The judgment I'm referring to, MWH versus NEH and another, and that is from the Free State Bloemfontein, penned by Mtimunye AJ on the 9th of January 2024, and the Safley citation ZAFSCHC 6. And for those of you who are following along on the bundle, page 169. I think for the next case, I'll tell you the bundle page first, and you can page furiously while I read out the citation. Then on your summaries, it is the very, very first one, page 1 of your summaries page. You will find MWH versus NEH and another. This is an appeal matter where there was an application to set aside a warrant of execution for a settlement agreement payment shortfall relating to a pension fund. Now, essentially, what had happened was in the pension or in the divorce decree, it was stated that X amount would be paid by the pension fund to the one party from the pension interests of the other. Lo and behold, when they received the fund payout or the payout from the pension fund, there was less money than they thought there would be, because the only thing in life that is really certain apart from death is taxes. And SARS had obviously taken their chunk of the funds that were paid out. The respondent then went to court, issued a warrant of execution, and the applicant, also being the appellant, the applicant took the matter on appeal, launched an application to have the warrant set aside. And the appellant's argument was simple, that she got the money, or he got the money. I can't remember the config of the parties, but the respondent got the money, and they need to pay the tax on it. The court, a quo, said that the warrant should not be set aside. It was then overturned by the Free State High Court, by sitting as two judges, Mtimunya AJ, who was who penned the judgment, and Mbele AJP was sitting as a quorum with them. This was an appeal from the regional court, so it was an application in the regional court. Let me quickly see. Stella asked, did the settlement agreement not make provision that the tax would be payable by the respondent? I'm quickly having a look. It was 1.4 million rand that was supposed to be paid from the pension interest of the respondent. In community, they entered into a settlement agreement which was made in order of court. I'm reading from paragraph 2. And thank you for the question, Stella. And folks, everyone watching, please do shoot with questions and comments and queries. I would really appreciate it if you would converse with me as much as possible, because unlike Teams, I'm not even speaking to aggressive initials. I'm just speaking into the ether and hoping for the best. So paragraph 2 says, upon divorce, they entered into a settlement agreement, which was made in order of court. In terms of the settlement, the appellant was to pay the first respondent amount of 1.4 million from the appellant's investment retirement plan and a retirement annuity held at Discovery and PPS. It says absolutely nothing about tax here. And I think this is where the problem came in. I surmise that if there was a full provision made for what would happen on in terms of tax, then the parties would not have this issue. So the appellant approached the court to rescind and set aside the writ on the basis that he had complied, as the shortfall was paid to SARS on the basis that the benefit became taxable in the first respondent's hands, and that by vacating her right, she waived her right to the shortfall, and that was just something else on the property. Magistrate blasted the appellant and said, no, writ stays. You did not comply. High Court disagreed and set aside the writ, and the High Court, sitting as a court of appeal, said, in my view, it follows, therefore, that if the interests in the policies were transferred to the first respondent, such would be taxable in the hands of the first respondent. The court is persuaded that the appellant had fully complied with the terms of the settlement agreement. Resultantly, the appeal must succeed. Stellas poses the question, is it bad drafting of a settlement agreement? Quite possibly. I think the fact that there was no provision for who would pay tax in terms of the pension interests, I think gave rise to some ambiguity and led to this matter going forward. I haven't seen the settlement agreement personally. I just see what the court says about it. So it is impossible to really say what the caliber of drafting was. It is, however, a cautionary tale to those of us drafting settlement agreements, whether attorney, advocate, mediator, paralegal, in whatever capacity. Be super careful when it comes to pension interest divisions. Right. A friendly reminder for those who joined us a little bit later, the thinklegal.co.za website is up and running. We have various resources on this website that may help you and your practice. We want to try and keep the family law roundup as freely available and free, not as free as possible. We want to keep it free. Unfortunately, we have to incur costs in terms of time, infrastructure, accreditation fees, etc., to run the program. A good way for you to support what Nadia and I are doing here is to visit the Think Legal shop. You're welcome to purchase our case law summaries, which look like so. It's 18 pages of summaries to fast track you into the judgments that we are discussing today. And you are also then welcome to register for the Children's Act deep dive. You are under no obligation to do so. If you are not able and you don't have the finances to purchase these, absolutely no worries at all. You are still more than welcome. But for those who do see that, who do believe that they can find value in these documents within their practice, you can go and pick them up from our online store. And for the SARM and social justice members and accredited mediators, if you attend today and you pick up the course material, you get a CPD certificate for 2 CPDs, and that is applicable for the rest of the year, because this course as a whole has been, every single session of this course will net you 2 CPDs with SARM or social justice, and I'm still awaiting feedback from the other constituent NABFAM bodies. As soon as those have come through, I will let you know. Moving swiftly along from Rule 43's pension interests and shameless plugs, let's move into the realms of parental responsibilities and rights. We have several very interesting judgments on parental responsibilities and rights, going all the way from termination, all the way through contact and care and guardianship and international travel out the other side. So please stick around. These should be, I think, or these are judgments which I think will give us quite a lot of food for thought when it comes to children's matters. We are, I would say, about just under halfway through the presentation today, so we are making fairly good time. I think I will have you home and dry by 10:30, back at your desks and rearing to go. Right, the first one that I would like to look at in terms of parental responsibilities and rights, CSS versus OR. This hails from Pretoria on the 18th of January 2024 under the pen of Puku AJ, and the citation on SAFLI ZAGP PHC 37. And this matter, if you would like to follow along, and I promised the guys of the bundles I would say this earlier, and I apologize that I didn't. It is on page 48 of your case law bundle, and you can find it on page 1 of your summaries. Now, this was an interesting care and contact urgent application, and it was basically for a return of 2 minor children before the starting of the school term. So what had happened in CSS versus OR is that the parties ended their relationship in 2020. The children initially stayed with the respondent and then moved over to the applicant due to financial difficulties. A dispute arose when the respondent simply removed the children and refused to return them. The applicant then quite correctly launched an urgent application for the return of the children. Now, this matter hails from urgent court, so obviously one of the chief issues addressed by the court is Rule 612 of the Uniform Rules, and what was focused on specifically is whether or not the applicant would have been able to get substantial redress at a later stage, and the court found obviously that the applicant would not find substantial redress. It looks at the best interest of the child. You'll see obviously in the next couple of judgments, every single one of them without fail cites Section 28.2 of the constitutional paramount importance of the best interest of the child, as well as Section 7 of the Children's Act. And then finally, the court discusses the role of the family advocate and how critical their job is in investigating the best interests of children regarding residency, care, and contact. So, what happened in this matter? The court put in interim arrangements to ensure that there is stability for the children. An order was made for the Office of the Family Advocate to investigate, and the parties were given leave to supplement their papers after receipt of the Family Advocate's report. And I'm quickly going to go through to the case law bundle, and I will share with you just the terms of the order itself. So let's go all the way up to page 50 odd. Let's have a look and just get our orders over here, and let's have a quick looky. I'm so sorry, folks, for the shameless scrolling. This matter, CSS versus AJ, it is earlier on. I've gone to the next one. Here we go. Provisions of the Uniform Rules of Court relating to time and service. Okay, let me just pop myself on the side so you can see a bit better. Are disposed of. Office of the Family Advocate. Pending the Family Advocate, children be placed in the care of the respondent subject to applicant's rights of contact, which shall be exercised as follows. Pending, respondent shall not be entitled to remove the children from Gauteng. Both parties given leave to supplement their papers. Obviously, a lot of discussion in this judgment, as in all of these types of judgments, regarding the factual matrix of the matter, and it is worthwhile to go and give that a read. The court makes two quite interesting, in my view, quotes, which I've highlighted for you, and they are as follows. The first one, paragraph 31. I will try and do my best to get the font up a little bit, but unfortunately sharing on this platform, it doesn't allow me to zoom as nicely as I would have liked, but I'll try the next time to just make it a little bit bigger. Paragraph 31 is very interesting in terms of the court adopting a child-centered approach and telling the parties off a little bit. The provisional measures are made not for the benefit of the parties, but only for the best interest of the two minor children. When parties are no longer together for one reason or another, they should try as far as possible not to use children to fight their battles. And absolutely ain't that the truth. Then paragraph 32, the court goes on and says, consequently, this court as upper guardian will grant a remedy that puts the best interest of the two minor children at the forefront. Their well-being and safety are what matters at the moment. Then just as a notable aside, paragraph 25, it's not up on your slide, the court just reiterates that the Constitution and the Children's Act are also clear that the rights of children must always be considered as a matter of priority. I found it interesting using the term a matter of priority in every matter involving children. So that is CSS versus OR, all the way from Pretoria, under the hand of Puku AJ on 18 January 2024. Right, moving on. UR versus SB. This is a brawl about schooling for a minor child. And this one also hails from Johannesburg. All of the Johannesburgers were in a fighting mood post December. I think it's everyone who didn't manage to get a holiday down at the coast was feeling a bit ornery and wanted to end up in court, I suppose. For those following along on the bundle, page 259, and if you are looking at the summaries, you can find them on page 2. UR versus SB and others. Johannesburg High Court, Safley citation ZAGPJHC 55, under the pen of Senyatsi J on 25 January 2024. What had happened was the following. Separated parents, there was a dispute over the enrollment of their child aged 7. The argument was essentially, should the child go to Redhill or should the child go to St. Stithians? The applicant wants the child returned to St. Stithians. Respondent wanted the child to remain at Redhill. Both schools had been considered. The parties had initially, and I think this was a turning point in this matter, agreed that the child would go to Redhill. Then the applicant wanted the child to go to St. Stithians, and then respondent said, no, Redhill it is, and an argument ensued. The applicant lodged the urgent application where they sought to have the child returned to St. Stithians. The respondent opposed it. Issues discussed in this judgment was obviously best interest of the child. As I mentioned to you, that's in each and every one of our judgments. That decisions regarding a child must prioritize their best interest with specific reference to education, care, and overall well-being. The parents are expected to co-parent and make joint decisions in the child's best interests. And then there was also some discussion regarding the role of parenting coordinators in these types of matters. Outcome was the court said the child should remain at Redhill and the parties should be jointly liable for school fees and for termination fees at St. Stithians. Now, this is a very useful judgment, folks, because of we know in terms of major decisions, we have this whole hurdy-gurdy in terms of, we know section 18, you need consent for those guardianship decisions, but then section 30 of the Children's Act says the parties can act independently. Then section 31(2) says if you want to take a major decision that affects the other parents' exercise of PRR, you have to seek their views and wishes. And where does schooling fall into this? And I like that the court really just said, court as upper guardian of all minor children must ensure that every decision taken about the child is in the child's best interest. So I think that really makes it clear that the door is open for parties to approach the court if they believe a decision that was taken, and this does not say a major decision taken, every decision. So this is not limited to section 31 major decisions. The court can intervene as upper guardian of all minor children. Obviously, don't approach the court capriciously or on petty grounds, but it is important to understand that the door is open. Now, what is very important in this matter, and I think this really comes down to the ratio of the court, is there was no unilateral decision to simply take S to Redhill. For fear of repetition, the parties knew all along that Redhill was their school of choice and the child was comfortable there. I find no basis to reject respondents' contention that S is excited about his new school and has expressed that excitement to family and friends. It will not be in his interest to remove him from Redhill to St. Stithians. And very importantly, the court focuses on the best interests of the child. Right, that is UR versus SB, the brawl about schools from the South Gauteng High Court in Johannesburg. Um, and that was under the pen of Senyatsi J. Then we move on to GD versus MM. Pratima says, I like that the court took notes of the child's excitement and that the child had expressed it. Great listening to the voice of the child. Absolutely. We know, obviously in these matters in terms of Section 10, the child has a right to participate in an age appropriate manner, and we must give due consideration to their views and wishes. And I think in this instance, the child had given their views and wishes. And I think, insofar as it tied in with the best interest standard, I think that's absolutely fantastic. So, GD versus MM, that judgment takes us all the way to the Johannesburg High Court again. And for those of you following along in the bundle, page 91, you can find the judgment. And on page 4 of your summaries, you can find the summary. And this is quite an interesting one. It deals with termination of parental responsibilities and rights, which is obviously quite an emotive and almost a controversial topic. So this judgment is GD versus MM, Safley citation ZAGPJHC 65, the judgment under the hand of Stradom J. Unfortunately, the judgment doesn't have a date on it. All I can tell you is that I got it in the last month through my absolutely fabulous Spartan case law updates. For those of you who don't subscribe to Louis and Soyon's service, please go and have a look at it. It is a really phenomenal service. I'm not getting paid to say that, incidentally. I just think it's a phenomenal service. You get an update every morning with at least 10 case law updates. Now, the updates that I've put in here, some of the judgments I got alerted to through their updates. Some I got through the GFLF. Some I got by absolute accident. Some I got from colleagues. But I can tell you that what we have here is not all of the family law matters, and there are quite a few more on Louis and Soyon's platform. So please do support them. It is very reasonable, 1.5 a year, and you get like an email every morning with cases and their summaries. Please go and support them. They are some of the good guys out there. And as I say, I am not affiliated or sponsored by them in any way. So this is GD versus MM, and it deals with termination of PRR post-divorce. So the divorce decree gave joint parental responsibilities and rights. Give me 1 sec, Jan-Louis, then I will quickly get the URL for you. Yep, annual membership is 1,500 Rand. It's like $130 a month. And it's just awesome. Tell Louis I sent you, and I'm sure they will keep you in the know nicely in terms of what's going on. It's 14 cases every day, so it's full head notes for 4 cases, and then 10 more recent cases arranged according to topic. Very, very cool service. So the divorce settlement in GD versus MM gave joint parental responsibilities and rights, primary residence with the father, specific contact rights with the mother. Father sought termination of mom's PRR. Mom opposed it, and she PRR, Sodia, is parental responsibilities and rights. And it is just an abbreviation that you use when your voice is like saying, I am now tired. So PRR, parental responsibilities and rights. Dad wanted to terminate mom's PRR. Mom said, I'm opposing the application. And then she sought a forensic assessment and for dad's consent to be substituted by the sheriff of the court if necessary, right? So the father alleged mom's absence, lack of contact as grounds. Mom said that she has some problems with her visa, and there was obstruction of contact as reasons for her counter application. Now, if one considers, folks, the provisions of Section 28 of the Children's Act, and I'm not going to put it up on the screen for you, but if you consider the factors that needs to be considered by the court in deciding whether or not to grant a termination, it looks at the degree of commitment that the parent has shown. It looks at things like the attitude of the parent toward um, uh, to award or to the exercise of parental responsibilities and rights. And then obviously it also looks at the best interests of the child standard. Now, in this instance, the father sought a termination. The mom opposed it and actually said, no, you know what? I want to be in this child's life. I want a forensic investigation. And I think the court then very wisely said, let's get an investigation. There's no hurry. We don't have to now just terminate. So if a parent wants to terminate contact, but the child wants to maintain contact, where to then, especially since it's inherently the child's right. Okay, so if you are talking about a parent that is not there, so let's say there's two different scenarios. So let's say the primary resident parent doesn't want to grant contact, but the child wants contact and the non-resident parent wants contact, then obviously it is a children's court matter. And the other way around, if the child wants contact, the primary resident parent wants to tender contact, but the non-resident parent doesn't want contact, I don't think there is any precedent that one can force somebody to be a parent or to be a good parent. I don't think there is such a mechanism. You can't force a relationship. That's my view, at least. I would actually love to hear from some of the other attendees in terms of their thoughts. But a very good question, Natasha, and I think one that unfortunately I don't have a clear-cut answer for you right now, but it is something that I think we can definitely discuss, or you can pop it on one of the WhatsApp groups. Advocate Doris Goodenough says, Natasha, there was a case many years ago where the respondent was actor Steve Hofmeyer. The court refused to force him to see his child. Okay. Thanks so much for that, Doris. If you don't mind, if you have the citation handy, please do pop it on the family law group, just so that Natasha can also find it there. For those of you who are living under a rock, who are not yet on the family law group, Ellen says happened with Nas Botha too. I remember that case. It was an incredibly sad case, that. On the family law group, go to thinklegal.coza, go to WhatsApp communities, follow the links, and then you can join the Think Legal Family Law group. We are a group of just under 600 family law crazies, all the way from attorneys, advocates, some presiding officers. We have some maintenance officers. We have some prosecutors. We have some psychologists, social workers, and a ton of mediators. And it is just a lovely place to discuss all things family law related. It is moderated and it is absolutely free, and you are more than welcome to join us. What I liked about GD versus MM, which was this where the father wanted to terminate parental responsibilities and rights, is Judge Stradom, who was dealing with the matter, took a very child-centric approach. And I think this paragraph 27 quote by Judge Stradom is one of the greats that I've come across this year. And I think it is so well stated that the right to contact or to be spared contact vests primarily in a child. And that one should take a child-centered approach. It's the right to contact is not as much the right of the parents as it is the right of the child, and the right to be spared contact. I like that term, which clearly implies that under certain circumstances, the child should be spared the trauma of contact if it is not in their best interests. Then paragraph 26, restating best interests is of paramount importance. Paragraph 31, restating the what we know, that the court has extremely wide powers in establishing what is in the best interests of minor or dependent children. And then quoting from FJ versus EJ at paragraph 32, the court says it is empowered and under a duty to consider and evaluate all relevant facts placed before it. Then paragraph 37 sets out nicely, I think, the ratio of the court. In my view, an assessment by a social worker and the FAO, Family Advocate's Office, will guide a court in respect of where the child is at emotionally, developmentally, and in respect of his relationship with the respective parties. Such assessment can further guide the parties in terms of how to best support the child in his relationship with each of the parties. And should there be a break in the relationship between the child and the mother, recommendations can be made in terms of how to best overcome the divide. Obviously, dad's application for termination dismissed, mom's counterclaim upheld, and an order made for forensic assessment. Absolutely, there are various provisions in the Children's Act for intervention mechanisms in terms of parenting. But obviously, if a parent says, I don't want contact, not in a month of Sundays, that obviously we still cannot force anyone to do. And I think, obviously, if one puts a parent in that position where they are forced, one shudders to think what the implications could be for the child to endure that behavior. Right, so DM versus CHP. This takes us to the Pretoria High Court. So finally, we have left the promised land and we've gone north over the Yukskay to page 57 in your case law bundle for those who have the resources, page 8 on our summaries. And this is a matter that was penned by DeForce AJ on 4th of January 2024, DM versus CHP, ZAGP PHC 76 Safley reference. And what had happened here was a order post-divorce for restoration of a status quo ante. What had happened is mom and dad were under a 50-50 contact regime post-divorce. Mom decided to relocate 500 kilometers away and presented it as a fait accompli to dad. I have simply gone, or 550 kilometers, don't forget the 50. And she limited the fathers to supervised contact for 4 hours every second week. Court was asked to restore the status quo pending investigation by the family advocate. The court very succinctly at paragraph 21 sets out the reasons for the order. Now, in this instance, I think the court is justified in restoring the status quo ante. And as far as that's concerned, the court said in paragraph 19, not on your screens, there can be no debate that a move of a child 550 kilometers away and restrict access to supervised contact for 4 hours every second weekend in a public place from a previous 50% contact regime is a decision which significantly changes and adversely affects the applicant's exercise of parental responsibilities. Now, why is that specific wording used? Because Section 31(2) of the Children's Act says that before taking a decision or a major decision, which for that paragraph is any decision which alters significantly the exercise of parental responsibilities and rights of a co-parent, you must first seek their views and wishes. So that's what the court is saying. The court is simply saying this case falls within the four walls of what is set out in section 31.2. Then the ratio of the court, incidentally, the court restored the status quo ante. I could have told you that. It's quite obvious. The court did the following. The court said that not only is the respondent's intended conduct a breach of the agreement in section 31.2, but it is one which introduces instability and a massive change to the child's life. Okay, now, three grounds raised here by the court in this one succinct sentence. The first reason is it is a breach of the agreement. So, in other words, pacta sunt servanda, people must be kept to their agreements. Then secondly, it's a breach of the Children's Act, section 31.2. And thirdly, it introduces instability and massive change. So then the court says, essentially, it wishes to enforce the agreement not purely for the sake of pacta sunt servanda, but also because stability and access to both parents is in fact in the best interest of the child at this stage. And it points out that these three factors dovetail. So it's a breach of agreement, breach of section 31, and it is a massive change in the child's life. DM versus CHP, that is from the Pretoria High Court under the pen of DeVos AJ, 4th of January. Folks, we are almost in our home stretch. I think we've got another 5 or 6 cases. I'm going to up the tempo a little bit just to make sure that we don't run over. In this instance, Valine, the court ordered, Valine asks, did the mom have to move back while the status quo ante was restored? Let me quickly go to the just go to the judgment itself. Then I'll quickly share it with you. Please forgive me again, guys. This is very, very small, and I can't seem to zoom in. DM versus CHP. The order was that. Here we go. Actually, I think, you know what? Yeah. It was the order was in front, and this was reasons for judgment. Apologies, guys. Yeah. In December, the order was granted. The applicant and the respondent retain full PRR. FAO requests to conduct an investigation. Pending FAO report, the status quo in respect of applicants' PRR and rights to maintain is restored ante omnia in accordance with the express agreement entered into between the parties on 24 Jan. To the extent that the removal of C from the court's jurisdiction interferes with the applicant's PRR, the respondent is ordered to return the child to the area of jurisdiction in order to ensure compliance with the express agreement. So she was not necessarily ordered to move back, but she was ordered to return the child. And I'm sure some very brisk negotiations between the attorneys ensued after that judgment. Right. HF versus PDJF. This is an interesting matter, which comes all the way from Johannesburg, again, from Joburg with love, under the pen of Ndlokovane AJ, and this was penned on the 31st of January. Bundle page 103. You see, guys, I'm not even trying to pretend I'm going to tell you early which bundle page it is, and I apologize. I'm simply absent-minded. And on your summaries, you can find it on page 11. This is an application in terms of section 18.5. So for those of you who aren't aware, section 18.5 says for factors such as removing a child from the Republic, passport, adoption, marriage, selling or encumbering immovable property, the 18.3C factors, as we call them, you need consent from both holders of guardianship unless there is a court order to the contrary. And this is exactly what had happened. The one parent living in the United States of America wanted to get consent to the child's intermittent international travel to exercise contact. In other words, they wanted their child to come visit them. There was a dispute by the parties, and the parent in the USA, in other words, sought authorization from the court under Section 18.5 for the child to come and visit them. The court discusses paramount importance. It discusses Section 18.3c, obviously, and then it discusses Section 18.5. Notable quotes from this judgment: I am of the firm view that the interim removal of the minor children in terms of appearing in my order above stated and ancillary relief therein is indeed in the children's best interest. Riva, I will be happy to send you a list of the judgments. I've unfortunately had to shut down a little bit in terms of how much information I share on the free platform. Unfortunately, it's come to my attention that there have been quite a few people plagiarizing the stuff that I've put together. So I've had to kind of be careful in terms of how much I put out there, but I certainly don't mind sending you a list of the judgments which were covered. Obviously, please just use with discretion. So yeah, in HF versus PDJF, I'm of the firm view that the interim removal of the minor children is indeed in the children's best interests. And then once again restated, as in our previous cases, the court has a duty to consider and evaluate as many factors as possible to decide what's in the child's best interests in this debate of interim removal. And in this case, the order was made, and it was quite interesting. The court didn't necessarily just dispense with the 18.3c factors. The court made a mandatory order that the respondent must sign the affidavits, that home affairs specimen affidavit, and then obviously various practical arrangements were put in place. CB versus KEB, and that matter is all the way from Pretoria, Malatsi Tefo AJ, bundle page 27, summary page 14. This is a matter with regards to schooling, and this comes from North Gauteng. Dispute between separated parents regarding the primary school enrollment of their child. They're already fighting like cat and dog very, very early on. There was an urgent application for appointment of an expert to do an assessment. There was a counterclaim for the applicant to enroll. The court analyzed the urgency of the application and all the rest. Under discussion, court's inherent jurisdiction, grounds for urgency, Section 28.2 of the Constitution, Section 7 and 9 of the Children's Act, and then, as I say, a full discussion on urgency. The court has some serious words to say. The court starts off this judgment, not on your screen, but the court says, when parents are in turmoil, children are the ones who feel the brunt. And the court basically has some very strong words for the parties in paragraph 24, saying, I would have struck the matter off the roll had it not involved the minor child and allowed it to take its normal course through the rolls. Nonetheless, it is now before me, and I will deal with it because it is in the interest of the minor child that a decision regarding her future be taken, given the failure of her parents to agree with each other. Some very strong words by the judge here, and from reading the judgment, I think quite justified, strong words. The decision as to which school a child should attend in situations where parents disagree is ultimately a matter of judicial discretion, exercising its inherent jurisdiction as upper guardian of minor child. Divina shares Jooste versus Botha, BCLR 187T, dealing with child's right to parental care under Section 28.1b. There is no legal duty to render the child love and affection. Thank you for sharing, Divina. Absolutely very sad, but very true. So, in CB versus KEB, the court basically said, schooling is urgent. I will make sure that this child goes to school. With the rest, it is not urgent. Get out of my court. Sound order, some strong words for the parents, and I think a cautionary tale on trying to reach agreement as far as possible. Then moving along, KA versus KN. This is our last children's matter or PRR matter for this webinar. You can find the summary on page 18, and the judgment is the very last one in your bundle, page 277. Guys, very important. Those who bought the bundle last night or before about 8 o'clock this morning, you will see that it is not there. There was an error with the first bundle uploaded. I have fixed it on the online shop. All you have to do is go and click on the link, which you would have received by email, and just download it again, and then you will have all the pages. I'm so sorry for the extra admin. There was a difficulty on the PDF, which I had downloaded. This is an appeal from the Randburg Children's Court. The appellant basically said that the magistrate had just rubber stamped the family advocate's recommendations and not adhering to a child-centric approach. The appeal essentially was dismissed. The court said there was no grounds to interfere with the Children's Court's discretional order. And what was interesting is, as we know, and as those of you who were in the Children's Court session with probono.org yesterday would have heard me say this, Children's Court is a journey. It's not a destination. And if you appeal a matter from a Children's Court, very often you appeal with another Children's Court date in the future. And in this instance, the court found that the subsequent and pending procedures were deemed to have potentially more of a relevant impact, thus rendering the appeal moot. It is tried that an appellate court will only interfere with the exercise of a true discretion in circumscribed circumstances in which such interference will be justified, or the circumstances in which such interference will be justified in case of vitiation by misdirection or irregularity, or the absence of grounds on which a court acting reasonably could have made the order in question. Righto. Now, very, very interesting judgment that we are going to move on to. Let me just quickly see why I am not getting my next slide. Cancel. No, I don't want to press plus. I want to go to the next slide. Sorry about that, guys. Simakuhle versus Simakuhle and another. This is all the way from Pretoria, also under the hands of Puku AJ. Paragraph 216 summary can be found on page 3, and this is a fascinating discussion on the interplay between customary law and our constitutional democracy. What had happened here was it was in the instance of burial rights in respect of a deceased under the Xhosa culture. And what had happened here is the applicant, who was the elder brother of the deceased, sought to exercise burial rights, contending that according to the tradition, the deceased must be buried in their ancestral home in the Eastern Cape. The wife of the deceased argued for her right to decide the burial location of her late husband, challenging the traditional view that places her in a subordinate decision-making position. The court did a very deep discussion on what the brother had done for the deceased versus what the wife had done for the deceased, and essentially said in paragraph 35, discrimination based on sex and gender no longer has a place in our constitutional democracy. Equality is at the core of our constitution. Then paragraph 34, I think the high watermark of the judgment. Applicant's case was largely premised on a wrong notion where women were always subordinated to the authority of a patriarch and regarded as perpetual minors under the disguise of cultural practices. This is no longer the position under our new constitutional dispensation. Application was dismissed. The wife was given the right to choose her husband's burial site, and she got an order for costs on a party and party scale. Once again, a reminder as we go into our final stretch, folks, we're going into now divorce and then procedural issues. Then I will release you into the wild again. Go check out thinklegal.co.za. You can pick up some interesting and hopefully useful resources for your practice there. Okay, let's go on to divorce. We've got ARS, Born K versus MSS. And incidentally, what's interesting these days is most of our divorce judgments, which I'm seeing come through lately, are either from Limpopo, Northwest, or Bloemfontein. We're just simply not seeing judgments coming through from the metropolitan, if we can call it that, the Johannesburg, Pretoria, Pietermaritzburg, Cape Town, and even Durban high courts at this stage, which I find very, very interesting. But that is just my own observation. ARS Born K versus MSS, ZA Limpopo, LMP PHC 10 is your SAFLI reference, and this matter deals with the issue of a forfeiture of patrimonial benefits under Section 9.1. Summary is on page 5 of your bundle, and the case itself is on page 1 of your case law bundle for those following along. Divorce proceedings, plaintiff sought forfeiture in terms of 9.1, basically saying that the defendant didn't contribute, and the old spiel, it was substantial misconduct, and. What the court did in this case, it's not a very long judgment to read, it's quite factual. It really comes down to the court saying that misconduct is not a standalone factor. It has to be considered with the other factors mentioned. And the court basically said at paragraph 13, this court does not think that the defendant will benefit unduly if forfeiture is not granted in this case. Remember, forfeiture is very much a discretionary thing. Section 9.1 says the court may, not the court must. So the court decided not to exercise its discretion in this matter. LE versus LA. Now, this was a fascinating one. It is as yet not on SAFLI. It was by Besaid Note AJ in the Johannesburg High Court, 9 February 2024, page 133 of your case law bundle, page 9 on your summaries. Now, this is a fascinating judgment where a party sought immediate division of a joint estate under Section 20 of the Matrimonial Property Act. In other words, I don't want to wait to be divorced, divide the joint estate immediately. There was a dispute on whether the marriage, these were two non-South African original citizens, if I can put it that. They were not from South Africa originally, and there was a dispute on whether the matter should be heard in terms of Turkish or Romanian law. The applicant launched an application for immediate division of the joint estate, and the court looked at a few interesting factors. The court looked at lex domicilii matrimoniae, the place of domicile of the marriage, which country's legal system applies to it. In terms of South Africa, in our courts, it still is followed quite universally that it follows the husband at the time of the marriage. That brings along with it, obviously, its own set of problems, but that's a discussion for another day. The court looked at Section 20 of the MPA, and then procedurally, the court also looked at the principle of making a case in reply and not complying with Rule 36.9 in terms of expert evidence. The court said, in my view, the underlying principles of lex domicilii matrimoniae remain the same. The MPA forms part of South African law. It does not apply to foreign marriages unless expressly provided for by way of ANC, as South African law is not the lex causae of such marriages. Application obviously did not succeed. the application for immediate division of the joint estate. This was in the context of a Rule 30 application. Hell of a judgment to read. It's quite a nice judgment in terms of a very, very broad discussion. It's about 17 pages. It's not too onerous. Well worth a read if you do decide to get the case law bundle. As I mentioned, this judgment particularly not yet available on Safley. NEM versus RLDM. Once again, we are in the realms of forfeiture. This is from the Bloemfontein High Court, Mtimunye AJ on 2 February 2024. Case law bundle, page 182, and your summaries bundle on page 13. If you have a look at page 13, you'll see it's a forfeiture of patrimonial benefits. Plaintiff once again sought decree of divorce, division of joint estate, and forfeiture of defendant's right, title, and interest into plaintiff's pension benefit at the GEPF. Defendant opposed the forfeiture, seeking pure division. And this forfeiture claim failed, folks. But I think the reason why it failed is because I don't think the plaintiff in this matter was a very good witness. Paragraph 19, the court just sets out the ratio. The court does a nice job in NEM of going through all the classical authorities. If my memory serves, it's either in MEN or NEM or the other forfeiture where it goes back to Vaker and it looks at all the classical forfeiture cases. Well worth a read just to see a nice pulling together. But there wasn't really a paragraph in this judgment that I thought, apart from this, which is the ratio, which is a notable quote. But essentially the court goes through the cross-examination of the plaintiff, and she said that he never contributed under cross-examination. Essentially, she conceded that there was contributions, etc. So the forfeiture claim failed. Then we go on to deceased estates, folks. Moshabane versus Mchaki. I'm loving this chat going on the right-hand side of my screen. I love how verbal everyone is today. It really is lucky to see everyone chatting and conversing with one another and throwing around ideas. So thank you for that, guys. Moshabane versus Mchaki and others. ZAECQBHC, and that is under the pen of Nomchembu J on the 25th of January in the Eastern Cape High Court. And that is on bundle page 150 and summary page 6. Whilst we're doing that, as we start wrapping up, can I ask those who've got the bundle, please to give me a little bit of feedback. I've been trying to fine-tune it between giving too much and giving too little. So this month's one, I think I've got a fair middle ground. Please let me know what your thoughts are. Is it working for you? Do you like it? Is it something useful that you think you could use in your practice? Because it obviously takes quite a bit of time to do. And if I do it, I want to make sure that it is useful for the people out there. So please give me your comments and tell me what you think. 3 minutes to go, 2 cases to go. We are officially racing the clock. What had happened here was that the applicant, this is on page 150 of the bundle, page 6 of the summaries, applicant challenged the validity of a will of a deceased, made all sorts of allegations, and essentially really wasn't very successful. And the court looks at a couple of things. It touches on marriages under the Black Administration Act, the Erstwhile Act. It looks at the Plascon-Evans rule, just restates it essentially, and it looks at requirements for valid service. The application was dismissed, but there is also something very interesting, and this is a cautionary tale to attorneys and advocates. If you ever act in your own capacity in matters. Paragraph 59, the court says, while I agree that the conduct of the applicant requires some serious censure, I'm not persuaded that a punitive cost order is the appropriate mechanism. Not only is the applicant an admitted attorney, she's also an officer of the court. How she conducts herself has serious ramifications. Her conduct in these proceedings raises some serious questions on her fitness to practice. I'm therefore of the view that this must be referred to the LPC. And a judgment was then made in that regard. So, cautionary tale. Contempt of court. This is all the way from, if my memory serves, this is from Cape Town. Yes, it is from the Western Cape High Court, Adhikari AJ, bundle page 116 and summary page 16. Guys, I'm probably going to go a minute or two over. Please do not have me shot at dawn as a result. JSH versus MSH and others, ZA Western Cape High Court 42, Safley reference, dated 16 February 2024. What had happened here was that the applicant brought contempt of court proceedings because the respondent had not, in her view, complied with payment for school fees under the Rule 43 order, which said that the respondent must pay for school fees. But the applicant insisted that the children must attend this school and no other school, and no more cost-effective school. This is where they must go, and he must pay. The court looked at the requirements for contempt of court. The court looked at non-disclosure of the fact that there was case management. The applicant didn't tell the court this, and it looked at the order of at the issue of costs and why the court didn't grant a cost order against the applicant despite her reprehensible conduct. Application was dismissed with costs to stand over. And a very interesting paragraph 39, what the court says, it is clear that the litigation in respect of interim maintenance will continue unabated until the divorce is settled or finally determined. Basically, I directed that the parties immediately approach Erasmus J's registrar to manage the further conduct of the divorce action. It's all about good faith discussion. Then finally, folks, I'm going to just alert you to TR versus SR, where a writ which was incorrectly issued was set aside. That is TR versus SRZA GP High Court 76 under the pen of Van Nieuwenhuizen AJ, page 237 of your bundle, and then page 6 of your summaries. A writ of execution will an application be set aside as incompetent if the judgment was not definite and certain as where the amount payable under the judgment can be ascertained only after deciding a further legal problem. There was quite a bit of controversy on this. Funds were paid into one attorney's account and there was a set-off and there were all sorts of things. I'm not going to go into too much detail. The principle is quite crisp. Then this is a stay of a warrant of execution under Rule 45 Cap A, RA versus FA, Western Cape High Court 35, Safley reference under the pen of Lekuleni J, page 191 of your bundle, page 12 of your summaries. And basically what happened here is the respondent got a Rule 43.6 order by a means that the applicant did not know that there was a Rule 43.6 order. The applicant missed the court date due to misinformation from his erstwhile attorneys. Order was granted in his absence and he wanted to rescind the order. The warrant was then issued by the respondent. The applicant then approached the court under Rule 45 Cap A, which is a suspension of the order. And this is the first time I've seen a judgment on Rule 45 Cap A. So I found it interesting for that regard. And what the court basically looked at was its discretionary power to suspend orders considering the interest of justice and the general principles for a stay of execution being real and substantial justice and obviously the applicant's prima facie right to bring a rescission application. And that is it for us today, folks. This is the Family Law Roundup February 2024, and I am now quite tired and quite tuckered out. I thank you for all of you who spent this hour and a half session with me going through the 20 cases that we are faced with from approximately end of January to February. There have already been 6 cases that have landed on my fabulous Spartan case law update, which I've already put on lock and load for next month. I've now realized 20 cases is the sweet spot, but I need to move my butt to get through them. So next month, I'll time myself a little bit better. Links will go out later today to register for all, in fact, of our case law updates up to the end of the year. Reminder for those of you who want some sweet, sweet NABFAM CPDs, register for the Children's Act Deep Dive again, 23 and 24 April, 5:30 to 8. It is a 2-evening session. General principles, children's litigation, frequently encountered issues. Folks, I have been Mervyn Vermeulen, and I thank you for spending a Friday morning with me. I hope that this was informative and interesting, and that you are now well up to speed on what's happening in the world of family law, case law. For more information, please pop through to thinklegal.co. You can see some of our previous sessions. You can register for upcoming sessions, view our online shop, join our WhatsApp communities. And for those of you on YouTube and LinkedIn, thank you for tuning in. Please drop us some comments if you enjoyed it. Please share the word, especially of our free WhatsApp community. The community just keeps growing and growing and growing, and the conversations are becoming more and more robust and meaty, and I really appreciate everyone who has time to put in some amazing feedback on that group, as I certainly didn't have this week, but the group just ticked over, and thank you for everyone there. So guys, have a lovely rest of your Friday. Go and have a good rest. Thank you for tuning in to the Family Law Roundup, February 2024. And I will see you guys all on Facebook land, WhatsApp land, LinkedIn land, and YouTube land. As my mother always used to say, go away. I will see you all next time. Thank you very much.